Shalom, Om Swastiastu, Namo Buddhaya. Good morning to all of the participants for this last constitutional conversation. My name is Muhammad Ihsan Alia, and on behalf of the Director of Pusat Studi Konstitusi, Pusako, Fakultas Hukum Universitas Andalas, please let me to welcome all of you to the last series of the constitutional conversation. This is a collaboration between Pusako and William and Mary Law School. This is also part of the internship program of Stephen Amendola. He is one of the students from the William and Mary Law School, and he's been hanging around with us, doing a lot of researches and seminar, talking about a lot of issues relating to the development of constitutional law and the trends in constitutional law and democracy itself. Today, we invite a very honorable guest, expert, I can say, that will also elaborately analyze about the recent issues regarding the democracy and constitutional court. He is the former of a Constitutional Court Justice of Republic Indonesia, and he is also one of the lecturer in the Faculty of Law, University of Udayana. Dr. E. Dewa Gede Palguna. Good morning, Your Excellency.
Good morning, Ihsan. How are you?
Good. We've been talking a lot through another forum, I guess, in another research forum. And Professor Palguna is a very disciplined. He's been in this room since 8:30, and I want to apologize to you, sir, because we have to delay it for a certain reason. But now we will start the session, and we will talk about the democracy and constitutional court with these two speakers or experts, I would say. But before I give the podium to our speaker, I would like to ask our director, Mr. Ferry Amsari, to give a welcome remarks before we start this event. Bang Ferry, are you available to speak right now?
Thank you, Ihsan, but I think this forum is not for me to speak something about anything. We actually give the podium directly to the expert guest and Stephen for giving their perspective. So I don't want to say anything about this topic. Thank you, Ihsan, for the opportunity.
Fair enough, sir. Fair enough.
Thank you.
Thank you. Okay, that is the welcome remarks, I can say, from the director of Pusako. And without further ado, I would like to pass the podium to Dr. Palguna to talk about the issues, democracy and constitutional court. Dr. Palguna, the time is yours.
Okay, thank you, Ihsan. Let me share my PowerPoint first. May I share my PowerPoint?
Yes, sure.
Yeah, okay. 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 Thank you for the organizer, Pusako. I think this is my second time to share my experience. Yeah, exactly. It's my experience during serving as the Justice of the Constitutional Court. Now we are talking about democracy and constitutional court. But first of all, I would like to make some acknowledgement that the following material presentation is taken from my course material titled Constitutional Court and Protection of Constitutional Rights, which I presented about a month ago at the forum called the Online Summer Course Program organized by the Faculty of Law, Universitas Diponegoro. Of course, there are only minor modifications in this presentation. We know that the establishment of the Constitutional Court was an inherent part of the country's constitutional amendment, the Constitution of 1945, and the court had been given a pivotal role within the reinvented constitutional democratic state of Indonesia, which now strongly uphold the supremacy of the Constitution principle. Now, why I called it reinvented constitutional democratic states? Since the pursuit for constitutional democratic state of Indonesia had clearly been stipulated in the preamble of our Constitution, especially paragraph 4, but unfortunately, it had never been appropriately elaborated in the articles of the Constitution prior to the amendment. Even to some extent, those articles contradictory to the preamble spirit. We know that constitutionalism is the first and foremost condition of a constitutional democratic state. One of the most important substances of constitutionalism is the idea that constitution is supreme in a particular country because it is a fundamental law to that country. This idea must be applied and actually upheld in the state's practices. This is from which the principle of supremacy of the Constitution derive. And the adoption of the Constitutional Court is to ensure that this principle works. In other words, the existence of the court is to safeguard the Constitution so as to make it to be observed and upheld in reality. That is, in states' daily practices. That's the reason why the Constitutional Court is given a nickname, the guardian of the Constitution. I think all students who are majoring constitutional law are very familiar with these principles, especially the case of Marbury versus Madison. It is where the principle says where the principles came from. Okay, according to Article 24C, paragraph 1 and 2 of our Constitution, the Constitution of 1945, the court, the Constitutional Court, whose decisions are final and has the jurisdictions at the first as well as the last instances. Firstly, to review the constitutionality of laws. Secondly, to decide dispute of authorities among state organs whose authorities are given by the Constitution. Thirdly, to decide the dissolution of political parties. Fourthly, to decide dispute on the result of general elections. And fifthly, give the decision on the opinion of the House who considers that the president and or the vice president had done some violations stipulated in the Constitution. And all the above mentioned description of jurisdiction of the court, directly or indirectly, relates to protections of constitutional rights, which is a kind of, we call it a kind of conditio sine qua non for any constitutional democratic state. Either such rights belong to individual or to legal persons, including state institutions, of course. Now, just to mention some instances, for examples. Now in the 21st century Indonesia, any law which either its enactment process or its substance is considered unconstitutional, that law can be reviewed before the court. And this is, I will elaborate it later. Another example. Now the government, the president, can no longer arbitrarily dissolve political parties which are considered opposing to the government or because they hold different political beliefs, as happened in the past, whether during the so-called Order Lama, or Old Order, or Order Baru, the New Order. Yeah. People can now freely form a political party based on their political belief, and now a political party can only be dissolved if it is proven that its ideology and or its purposes, its programs, activities are against or contradictory to the Constitution. That's the only reasons how or why a political party be dissolved, and through the Constitutional Court, of course. Now the People Consultative Assembly, another example. Now the People Consultative Assembly, or the MPR, can no longer oust the president solely based on the Assembly's own political consideration, as happened in the past. Yeah. For now, the president is directly elected by the people through popular vote mechanism, instead of selected or appointed by the Assembly as practiced in the past prior to the amendment of our Constitution. And now, every single vote casted during the general elections, either to vote president and vice president, or to vote for members of a national and regional House of Representatives, or for members of Regional Representative Council, or DPD, counts. Contrary to the past practice during the heyday of New Order regime, where no legal remedy to settle disputes on the result of general elections, now such disputes can be brought before the Constitutional Court for settlement. Let's now we talk more about protection of constitutional rights as one of the most important substance of a constitutional democratic state. Now, every single citizen of the Republic of Indonesia who considers that her or his constitutional rights infringed by a law is given a standing to file a petition for judicial review on the constitutionality of the law before the Constitutional Court, and ask the court to declare the law unconstitutional. A petition for judicial review of law may be directed at either the constitutionality of its process of enactment, or of its substance, whether its articles, its paragraphs of an article, or parts of the law. If a petition is directed to the constitutionality of the law's enactment process, such petition is called in our legal system formal judicial review. While if the petition is directed to the law substance, for example, to some articles, paragraphs, or parts of the law, this petition is called material judicial review. To file a petition for judicial review, a citizen doesn't even have to be represented by a lawyer, but recently, for technical reasons, a petition without the presence of a lawyer was very rare. But there is no obligation that a petition for judicial review must be represented by a lawyer. This is how we try to make closer to the justice seekers, to make an easier access to justice. And if a petition is reasoned or founded, the court will declare that the law is unconstitutional and is no longer has its legally binding power, either wholly or partly, which depends on whether the founded petition is formal or material judicial review, as mentioned earlier. If a formal judicial review petition is granted, meaning that the petition is reasoned or founded, then the court will declare the whole law is unconstitutional and no longer has its legally binding power. While in the case of a material judicial review, if it is granted, the court will declare only the substance of the law concerned is unconstitutional and is no longer has its legally binding power. The whole process is free of charge, except if the parties concerned, the petitioner, the lawmaker, or the president want to submit witness or experts to be heard before the court. They must pay for them, of course, on their own expense. But there were occasions in which the court itself considered that it needed to hear some particular witnesses or experts. In such cases, the financial burden was laid on the court. It might be summarized that now, in the 21st century Indonesia, a single citizen of the Republic is constitutionally given a right to challenge a law which, according to our constitution, is a joint product of two democratically elected state organs. In this case, the House of Representatives and the President, to some particular issues, even plus the Regional Representative Council. It's very meaningful to be a citizen of the Republic of Indonesia today in the 21st century Indonesia. Let me now talk a little bit about the court digitalizations. Yeah, as we know, the Constitutional Court has the motto reads in bahasa Indonesia sebagai pengadilan modern dan terpercaya, a modern and trusted court. Guided by a vision, become a modern and most trusted judiciary, the court since the very beginning of its existence has adopted and continuously updating technologies considered relevant to optimize its performance, especially in the field of information and communications. This is a significant effort to maximize access to justice for those concerned, especially justice seekers. The court had created and developed a judicial system based on information and communication technology, or we call it ICT, called the E-Judiciary. It had been used to provide extensive and convenient access to justice seekers across the country. This includes electronic filing, video conference, court recording system, case retrieval system, and live streaming. Iksan, how many times do I have to present my presentation?
Generally, you have 15 minutes. So
it's already.
I guess it's already like 10 minutes. So,
okay.
But I told you, the time is yours. If you want extra time,
okay,
you'll be more than welcome to do so.
Okay, thank you. I will try to discipline myself.
Sure.
Okay. Now let me say about electronic filing. Now, within the operation of online application system, applicants or petitioner don't need to come physically to the court building to submit their application or petition. The system is very helpful, not only in terms of broadening access to justice, but especially in terms of efficiency. However, there are three main challenges here. Firstly, with such the vast territory of the archipelago, not all regions in the country have sufficient and equal internet access. Secondly, not all people, especially justice seekers, understand the online application technology, let alone of being accustomed with it. And thirdly, the biggest one is to change habit, to move on from conventional mechanism, carrying physical application files and evidences, to the paperless mechanism provided by this online system, of course. let me say now about e-case registration. Should an application submitted to the court meets the needed requirement, it will be directly recorded and electronically registered in the e-case registration system. The system is significantly helped the court staff in arranging and scheduling effective hearings, as well as ensuring that the case management process are handled quickly and optimal. Those benefits are possible because, unlike the old or conventional system in which calculation and arrangement of hearing must be done manually, the new system can help to record a case, identify a suitable slot for hearing, and find out how long will it take for a case to be examined and heard. And the parties concerned and the general public can see the progress of a case by visiting the court website, www.mahkamahkonstitusi.go.id. Okay. It means that the court website, at the very least, eliminates the need of parties to contact the court staffs only to find out hearing schedules and or the progress of a particular case. And in addition, the court had decided that the documents submitted by the parties will become public documents. It means that the general public is given an access to read the documents through the court website, so they will be better understand the case being examined by the court, especially those which attract public attention. And it happened lately. In the case of Undang-Undang KPK and the law on constitutional court itself, and maybe later the omnibus law, the judicial review of the omnibus law. Now, the process of the court hearings can also be carried out by using video conference. For years, the court has developed cooperation with 42 universities in 34 provinces, including Andalas, of course, throughout the country to place its video conference facilities and devices, which are owned by the court, but the daily maintenance of them is carried out by local staffs assigned by the university where the facilities are installed. With these facilities, all Indonesian regions are now connected to the court, which is located in the capital of the Republic of Indonesia. Thus, the parties to a case, especially petitioners, can simply go to the nearest university to conduct hearings. Distance is no longer an obstacle now, and no longer costly and time-consuming, since, for example, if they have witness and or experts to be heard before the court, they no longer need to fly to Jakarta. Now, okay, with this and with these video conference facilities, the court can hear testimonies and or experts' opinions not only within the scope of the country's territory, but also from other continents around the globe. In the meantime, when these facilities are not being used by the court, they can be utilized to fulfill academic purposes, such as to organize public lectures with universities within Indonesia and abroad, which can be reach a large number of participants. And now we are talking about the case tracking system. With a view to make information more transparent, the court implemented a policy to uphold that to upload every application file along with other relevant documents from the parties into the court website. With this policy, anyone, especially the parties to a case, can search the ongoing case to find out the next court hearing schedule or when the decision of the court will be read. And now, the last, I think, before the last thing I would like to present here is about the video streaming. It's also quite important and quite interesting. Lately, the use of the ICT is also implemented through video streaming, available on the court website by broadcasting the whole hearing process live. This facility enables the general public to follow the court hearings without having to attend the courtrooms, especially in high-profile cases like the case of election for president and vice president in 2019, where the justice of the justices of the court, hear the case until the next day. And now the court had expanded the access to video streaming by connecting it to the court YouTube channel, which has been subscribed up to this very day, around 30,000 subscribers, quite significant numbers for a non-entertainment channel, I think. And the court recording system. I think I have I have surfaced the time available for me, and you can see all the materials with the organizers. So terima kasih, thank you very much. The time is back to Iksan. Thank you.
Thank you, Professor Parguna. Well, ladies and gentlemen, you have been enlightened by Professor Parguna's presentation. He has keenly elaborated the historical timeline of Indonesian Constitutional Court and how our constitution evolved through a better constitutionalism. He has also explained a detailed practical and procedural explanation regarding the judicial review in the Constitutional Court of Republic Indonesia, and talking about the latest innovation to adapt to the digitalization era. So E-Judiciary, electronic filing, video conference, and video streaming is part of innovation that has been done by the Indonesian Constitutional Court in order to enhance the performance of the court itself. Now, I would like to pass the mic to Stephen. You will have 15 minutes to present your analysis as well. And after Stephen's presentation, I would like to ask Dr. Parguna to firstly comment or give some question regarding Stephen's presentation. And after that, at the same time, Stephen, I will also ask you to give some question regarding Professor Parguna's presentation. So, Stephen, are you ready?
Yes, I am.
All right. Okay. Can you bring the mic closer to you, because your sound is not really.
Yes. How's the sound now?
That's perfect. Okay. The time is yours.
Perfect. So I will share the screen on my presentation here. I'm just figuring out this. Version's not allowing me to click directly on the field. Hold on, I'll stop sharing for a moment so I can begin the presentation. Guy's actually giving me a bit of trouble all of a sudden, just being slow.
Is there any difficulties you find there?
Yes, for some reason it's just being slow to actually respond to my commands, not starting the presentation for me. I'll close the program and reopen it. That should probably do it. Apologize.
Or maybe you can forward your presentation to Ari, so Ari will be the one to share the screen.
Let's see. Well, I think, okay, yes, that did work, reopening it. But yes, I would have tried that next. All right, so now I can share the screen. Yeah. So yes, this is my portion of the presentation on democracy in the Constitutional Court. For this side, I will be comparing it to the United States system of its own constitutional review and how that interfaces with our democracy. Justice Palguna, it's an honor to be presenting beside you. As you're probably aware, there is no independent constitutional court in the United States. Here in Article 3, which is the portion of our Constitution which defines the judicial power of the United States and the structure of its courts, it says that it shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish, which actually would forbid the creation of something exactly like you have in Indonesia, where there is a Supreme Court attending regular matters of law and a separate court for constitutional review. In our case, the same Supreme Court handles both of these, and this actually does create something of a messy situation. Oftentimes, questions of constitutional review are bound up in questions of regular cases of law. Far more often, when serious constitutional review happens, it's happening as something attending another case on another legal matter, which does have some disadvantages. Another feature of this, when it says "and in such inferior courts as the Congress may from time to time ordain and establish," this is referring to the federal judicial courts. There is now a three-tiered appellate federal court system, and the federal district courts, the lowest trial courts which exist in the federal system, have as much power of constitutional review as does the United States Supreme Court. So the federal district of the federal district court of the Southern District of Florida, the Middle District of Pennsylvania, wherever it may be, actually has an equal power to overturn laws as violating the United States Constitution. But then, of course, those are subject to the review of the United States Court of Appeals and the United States Supreme Court. But yes, the judicial power is at least uniform in that sense between the different levels of the federal judiciary. The judicial power extends to all cases in law and equity. That the consequences of this construct is that unlike in Indonesia, where a citizen may simply file to the Constitutional Court directly for review of a constitutional question, whether a law is unconstitutional, have a case reviewed directly on the constitutionality of a law, there is no really equivalent procedure under the United States. When a citizen wants constitutional review of a law, they have to file a lawsuit. This could even be a lawsuit against another litigant, somebody who has committed a tort against them. They could sue. There can be lawsuits against states or state administrative bodies for the constitutionality of laws, but you also have to have standing, which is an important decision. An important factor. You must be subject to the constitutional violations of that law in some way demonstrable to the procedural standards of the court, in order to even be able to file a lawsuit that will then receive a constitutional review. So it is substantially harder for the average citizen to access the constitutional review of the Supreme Court in the United States than it is in Indonesia. It is a federal rather than unitary republic, and that does create a lot of complications. The basic structure of the system is a lot more complicated. It causes disuniformity in an important way. So yes, the average U.S. citizen, they have significantly less ease of access. There is an independent court system between the federal judiciary, the three tiers I just described, the federal district courts, the courts of appeals, and the Supreme Court, and the states. Each of the 50 states and some of the territories, they all have their own completely independent court systems, which are subject to appeal by the United States Supreme Court, but only at the final level at their state Supreme Court, and then only on where they've decided questions on federal law, or where there is a substantive civil rights issue in violation being addressed. They need to take that to a federal case, but they can do it. But it's difficult, and the procedural requirements are specific and require a lot of specialized knowledge. The state judiciary courts can actually have as many structures for the appellate system as they want, and they're very different from place to place, which creates the complication that a lot of people don't know exactly where to go in order to have their cases filed. If they have a question of constitutional law, they don't know whether they should go to a federal court or to a local state court, and they don't know what procedural and legal difficulties will attend them once they do so. This is the appellate pathway by which anyone can get to the Supreme Court. As I mentioned, a lawsuit must first ensue. They cannot simply say, I believe this law is unconstitutional, may I have a review? There is no procedure permitting that. The United States Supreme Court has very limited jurisdiction in terms of the types and number of cases they'll take. They may only review cases directly from a federal appeals court, a United States Circuit Court of Appeals, or from the Supreme Court of various states. And they can only do so under specific legal criteria. It is also purely voluntary. The Supreme Court it can grant writs of certiorari over the cases it wishes to hear, but it is under no obligation to do so, and so most people are unable to reach its review. The 1925 Judges Bill, or Certiorari Act, or Judiciary Act, it had several names. It did set this up in order to reduce the workload of the Supreme Court, because up until that time, the Supreme Court had been hearing thousands of cases a year and was saying that it was overworked, that it was unable to meet with excellent judicial reasoning the number of cases it had. It also established technically a procedure by which any lower court could certify a question to the Supreme Court directly, as in without having it review an entire case. One of the lower courts could say, it could just issue a certification to the Supreme Court requesting its determination on a sole issue of law. Is this law constitutional? We so certify. But this has actually never been done since the creation of the law. And so in practice, the Supreme Court only hears cases voluntarily by writ of certiorari from these two types of cases. And it only hears approximately 80 cases per year, incidentally. That's a more recent development. There were times in the court's history where that was not the case. This is the federal structure of the judiciary, the structure of the federal judiciary. So there are 94 district courts. District courts form you see these in the image. If you're able to see that, there are little boundaries inside the states that tell you where some of the states are subdivided into federal districts. So you can see Pennsylvania has a western, middle, and eastern district. New York is divided into 4 federal districts. Some states are just sole federal districts, but each of those federal districts fall under a federal judicial district, which is one of 13. And those are marked out on the map as well. The ones that are truly regional, actually, there's only 11, so you'll only see the numbers up to 11. Then additionally, there is the DC Circuit, which handles a lot of very specialized issues of federal law. They do a lot of review of administrative agencies, things like that. And the Federal Circuit Court of Appeals, which handles matters of international trade and predominantly of patent law, because they determined at some point that there was a need for federal uniformity on the question of patent law. But that sort of already gives you a hint of what I'm going to talk about a little more, is that between these 13 circuits, there is a great deal of disuniformity in the law, as well as between all of these states. Federal courts themselves are courts of limited subject matter jurisdiction, whereas a state court can hear any case lawfully filed before it. The subject matter is never going to determine what they can hear, unless that state is divided up into, this is the family court, this is the tax court, this is the criminal court. Sometimes they do that, but state courts broadly have any kind of power to hear a case. The federal subject matter jurisdiction consists of federal question jurisdiction, diversity jurisdiction, and supplemental jurisdiction. Federal question jurisdiction is derived from the text of the Article 3 of the Constitution I mentioned before. Just any case that actually pertains to federal law directly is something that the federal courts can hear. But this is a fairly limited area of law. I mean, there's many cases on it, don't get me wrong, but it's often not things that affect the average citizen of the United States very directly. Diversity jurisdiction is the way most average people are able to get their cases into a federal court if they want it. The diversity jurisdiction comes from 28 U.S. Code Section 1332 that involves, if the citizens have a lawsuit and both of them are from different U.S. states and the amount in controversy is at least $75,000, then that case, although it be a matter of state law, can be heard by a federal court. As you can see, that's a fairly onerous requirement, and it is a lot more difficult to have a case heard in a federal court than it is to have it heard in a state court. And this requirement can come up as well, because, for instance, if a case actually lacked the correct subject matter for the federal court to have subject matter jurisdiction over it, the case can be overturned on that basis even after it's been decided, and even after it's been appealed and decided, and the case could go to the United States Supreme Court and still be voided for lack of original federal subject matter jurisdiction, which is sometimes a difficult and nuanced point for lawyers to figure out. So this is another way that under our democracy, the Supreme Court can be quite inaccessible. This is just an image of various states of court structures. I mentioned how in the state structures of the judiciary, they can do it any way they want. So they have, they can make it more and less logical. A lot of them are fairly uniform. They generally have a three-tier appellate system like the federal court, particularly the states out on the western part of the country, where their court systems were established long after the federal government had long established itself as a distinct entity. Whereas you go to the states in the east, such as New York, and you can see versus these other ones, which have fairly logical, fairly orderly, fairly subject matter based, straight up appeals. New York, which is on the eastern portion of the country, and so was around prior to the formation of the Constitution, and so did not closely base its judicial structure on the structure of the federal government. They even confusingly call their Supreme Court a court of appeals, and you can see on the bottom they actually have lower courts that are called Supreme Courts, and there's a lot more internecine involvement of appellate procedure, things going up and down, etc. So that's another thing. Any U.S. citizen, they're also a citizen of a particular state, and they must know the requirements that attend them in the state courts, the appellate procedures that will get there. And it's not until they get through all these specified procedures of that particular state, which differ in 50 ways, that they can even try and receive a writ of certiorari from the Supreme Court, which makes that substantial for the purposes of democracy, the protection of constitutional rights, and review by the Supreme Court, because the states are highly ununiform, highly politically polarized, which I'll get to. On the matter of states courts specifically, as I mentioned, there are courts of general subject matter jurisdiction. There's no type of case they can't hear, except something that is exclusively on questions of federal law. They do have the ability to review questions of federal law before them, but they must be supplemental to the case. They can't be, the case cannot be primarily about federal law. But this is also like supplemental federal jurisdiction, which I mentioned, in which they can review questions that would otherwise not have subject matter jurisdiction in the federal court, so long as it's sort of ancillary or on the side of the issue of federal law that is central to the case. The state courts, in addition to being bound by the United States Constitution and the federal statutes which might apply to the case, they are also ruling on their respective state constitutions, their respective state laws, which do differ in substantial ways. Sometimes they're based on the U.S. Constitution, and so there doesn't end up being a lot of difference, but one does have substantially different rights from state to state, depending on how their constitution in that state is written. The vast majority of criminal cases are handled on the state level, as well as tort cases, just your average lawsuit, suits over contract, family law matters. Almost all lawsuits that you're going to experience in the United States will be at a state court. Their volume is substantially greater than the federal court system. And so far more of the justice and the access to justice, which occurs under this democracy, occurs at these state level courts, who have very different requirements, so ones that a lot of people, even in the United States, are surprised to hear when you get into the specifics of it. For instance, state courts may still use the common law, that notion of the law being made up by the general consensus of the presidential environments of the laws which have been proceeding in English courts since the 12th century. But sort of as an inadvertent result of a federal case, there are now 50 unique presidential environments for the common law. So there is a Kansas common law, there is a New Jersey common law, there's a New York common law, California common law, because they have been isolated into distinct presidential environments in which only their own rulings are binding on them, which is the notion that we now call stare decisis, which is newer than the common law system itself. It is from the 19th century that we started employing this harder method of stare decisis, where cases that have authority over the court ruling the present case are actually binding on that court unless they have the power to overturn it. And then if they do have the power to overturn it, they must have a good reason to overturn it. It's something procedurally well established. That is far more strict than the common law, which used to just say a body of cases that show generally the effect of the law are evidence of what the law is. And so based on the common law presidential environment of the state you're in, you might, again, have substantially different rights, substantially different remedies for ways in which your rights might be violated, or by either by the government itself or by other human beings or by corporations, etc. Additionally, the United States Bill of Rights did not initially apply to the state governments themselves. It always applied to the federal government specifically, but they turned down the notion that it was meant to inhibit the state government from doing anything. So although you had the right not to be interfered on the specific rights in the Bill of Rights by the federal government, you actually had no such right by the state governments. In practice, their powers can be thought of as nearly unlimited, though at this point, many aspects of the Bill of Rights have been incorporated against the states. Ever since the passage of the 14th Amendment, the what they call the Substantive Due Process Clause has now permitted incorporation of the Bill of Rights against the states, but it's an incomplete process. Not every right in the Bill of Rights has yet been incorporated against the states, including freedom from quartering of soldiers, the exclusion of unlawfully acquired evidence, the right to an indictment by a jury trial, the right to a jury from made up of people from who live where the crime occurred, which actually has substantial implications for the basic justice of our criminal system, which there is much popular criticism from all sides. The right to a jury trial in a civil case, and in fact, the right to a jury trial and a trial under equity has never been established under the United States Constitution. It's actually not written there. Or the right to be free from re-examination of matters of fact. A federal case, a federal appellate court, such as the United States Court of Appeals or the United States Supreme Court, cannot review questions of fact that were decided at the trial level, but state courts, appellate courts, and Supreme Courts may do that as much as they like. Even very important rights, such as the right against self-crimination, was not incorporated against the states until 1966 with the famous Miranda case, where now in the United States movies, you hear the police officers reading people their Miranda rights as they're arrested. A lot of people are shocked to hear that. There are many aspects of the structure of the republic which are not commonly taught in our public education systems. So there is notably a great deal of disuniformity in the systems. As I mentioned, the states may still use the common law. There used to be a federal general common law, which did impart a certain level of uniformity that can no longer be enjoyed because the federal courts were capable of employing their own interpretation of the common law and deciding questions of state law under diversity cases, which are the vast majority of cases which are brought under it. I just saw your message, Iksan, sir. How much time do I have left, or am I already over?
I think you have another 5 minutes to finish it, sir.
Excellent, thank you. Yeah, I'll try and go as quick as I can through the remaining. A case called Irreversible versus Tompkins abrogated the existence of federal general common law. Now the federal courts are required to use those state courts' interpretation of the common law in order to decide state questions of common law. This results in further disuniformity. Each of the 13 federal judicial districts I told you about, each of those are presided over by a United States Court of Appeals. Each of those are a distinct precedential environment in which the rulings of that court are binding on the courts under that circuit, but not on the other courts. Consequently, there are intra-circuit splits. There are places in which the federal law is actually interpreted and held differently, depending on where you are in those geographic regions that I pointed out. There's also a prior panel precedent rule, which now exists. This is only from about the 1950s. It's an even stricter interpretation of stare decisis, wherein a United States Court of Appeals is bound entirely by the ruling of a prior panel within their presidential environment, unless the case meets en banc, which that is every case under the United States Court of Appeals meets with a 3-judge panel, but they are in fact composed of far more judges. If they meet en banc, they meet with all of them. Only meeting en banc does the court have the ability to abrogate any prior decision by United States Court of Appeals, unless a intervening United States Supreme Court ruling has abrogated it incidentally. The federal district courts are not bound by their own precedent because they would be the level that would have the power to overturn it, but they are bound by the precedent of the various judicial districts I mentioned. Federal courts must actually certify questions to state Supreme Courts when they feel that there is ambiguity in the ruling of that question. And so substantive differences in the constitutional rights that people have under the United States Constitution actually exist between different states, which may either respect those rights in practice to varying degrees, sometimes to utter violation of it, and then also between the 13 different judicial circuits. For instance, a citizen living under the 8th Circuit on the map I showed you before are not free from the reasonable mistakes of law by police officers, whereas they are under every other circuit. And questions of the Fourth Amendment, questions about criminal procedure, things that do really substantially affect the constitutional rights of people are in fact not uniform depending on which judicial circuit you live in. And most people are probably not even aware off the top of their head which judicial district they live in or how that impacts their rights. But in fact, it substantially does, sometimes to disastrous results. Recently in the United States, there's been an increasing trend of political polarization to a large extent. You can see the groups of people I have on the bottom image there. On the left are 62 United States senators, of which there are 100, who represent 1/4 of the total population of the United States by numbers. On the right are 6 senators who represent an equal number of the population, because every state in the United States Senate has equal representation of 2 senators. That's written in the Constitution, and it's actually entrenched against constitutional amendment. But because many of the states have significantly higher populations than many of the other states, the result of this is you have a highly imbalanced voting power in the Senate of low population states. This also ends up affecting the judicial presidential environment by creating highly politically polarized situations throughout the country generally. You can see this map of 1996 and 2016. They show the by the density of the color and the brightness of the color, they show how overwhelming the majority by that party is, either the Democratic or the Republican Party by county. By 2016, the polarization gets far more dense, and this ends up influencing the polarization of decisions that are actually handed down by the United States Courts of Appeals and by the United States Supreme Court. It is now a highly polarized issue what the party makeup of is of the constitutional of the United States Supreme Court bench, which used to be far less important issue. First past the post voting also ends up polarizing candidates who then go on to select Supreme Court justices, because mathematically it predetermines that only 2 viable candidates exist. United States senators and representatives are elected by local districts rather than by a national vote, which has implications as to segregation. Racial segregation has created the situation of imbalanced partisanship, because they have actually relegated subaltern populations into geographic regions, which can then be districted both in terms of the judiciary and in terms of elections. And around 1996 is the time we stopped a policy called desegregation busing, in which we actually brought children from various neighborhoods into neighborhoods in which they previously would have been racially excluded. That policy had been working, but now that it's been stopped, racial segregation is now back to where it was back in the 1960s in the United States. It's the worst it's ever been. That is also attended equally by the problem of political polarization that you see depicted here. The one Supreme Court here on the left, I have depicted the various chambers in which the United States Supreme Court has met. The bottom left is the current building in which they meet. They have original jurisdiction over matters affecting ambassadors, admiralty law, like very important, very specialized questions. They hear very few cases on original jurisdiction. If you are a regular citizen of the United States, you have a case that you want to go to appeal to the United States Supreme Court. Our citizens are mostly under the impression that they can do that. In fact, it's like a common thing in personal arguments. You'll hear people say, I'll fight you on that if I have to take you to the Supreme Court. But in fact, there is no right of appeal to the Supreme Court, no differentiated right, at least. One can incidentally get there if they follow all the procedures correctly, and the Supreme Court voluntarily gives its discretion. There used to be compulsory jurisdiction to the Supreme Court on certain matters, but because it was affecting their workload, the only case under which you have a right of appeal, it has to do with district courts that meet in panels of 3 under a very specific procedural situation, and those only concern like electoral redistricting matters. Otherwise, in general, 1% of all federal cases filed go to a federal trial. 1% of all those trials decided actually receive an appeal by a United States Circuit Court of Appeals, and 1% of all of those cases are granted a writ of certiorari by the United States Supreme Court, which means that they hear roughly 80 cases per year, which exacerbates the disuniformity between the circuits and between the states, because when there's inter-circuit conflicts, it's generally just highly unlikely by numbers that out of the 80 cases per year the United States Supreme Court hears, it will get to that issue. And so many fractured constitutional right protections, depending on where you are in the United States, remain. See, with limited time left, I think I covered some of this in the previous. Yes, I will go. Oh, well, here on the bottom point here, fairly sophisticated legal knowledge is also required. So not only is that numbers game hard to get through to get to be one of those 80 cases, but the United States Supreme Court has such procedures and standards, standards of review, standards for on which appeals writs of certiorari are granted, as do the lower courts between them. That in order for a case to actually have the specific factual circumstances that will trigger a contested lawsuit, that the only resolution for is the overturning of an unconstitutional law, it has to be an extremely specific type of situation. And in general, it's such a specific situation that sometimes they have to forge that situation, such as there was a famous Scopes monkey trial about which one stated made it illegal to teach evolution. There was a case in Lawrence v. Texas where they just actually had to arrange for somebody to be doing the crime of a law that they felt was unconstitutional and then be caught. Otherwise, if you're not already an attorney, you're generally not going to have the ability to reach the United States Supreme Court. There are some political activist organizations like the ACLU, the NRA, the Southern Poverty Law Center that look for people with those factual circumstances in order to get regular people to have, be able to have situations that reach the Supreme Court. But this is still mostly for their own political reasons, for the testing of constitutional law questions that moneyed interest groups believe are important. The United States Republic is a model of agrarian slave republic. We have now abrogated slavery, but the vestiges of the system still exist. And they're modeled after the ancient republic because they're breaking away from monarchy. So they're modeled on sort of the notion of the Roman gens, that you have an agrarian family unit. At the top of that unit is a well-educated landed gentleman who meets certain standards of virtue and citizenship that were written about back in ancient Rome and in ancient Greece. The founding fathers talk explicitly about this model, which is why under the original United States Constitution, only 6% of the total electorate could actually vote, that being white landholding gentlemen above the age of 21. That's been expanded. Now, there's a much larger portion of the eligible voting population, but there are structural things remaining in our system from the fact that it had been designed that way. And in fact, the whole model of free citizenship that we now use in most of the developed world and beyond, it comes from a lot of the legal influences out of the document Magna Carta, that was signed by bad King John back in England. And certain articles of Magna Carta were expanded to create this model of citizenship that we have now. But Magna Carta was a document that was signed to surety barons, people with a very specific kind of position in society. And to this day, most people who receive access to justice, who can actually get remedies on a question of constitutional law, are going to be landed gentlemen or people who are in fact wealthy enough to have the legal resources, to have the educational resources, to have the kind of information that they want, that'll be necessary to craft a case that will in fact reach the Supreme Court. It's a very unfortunate. It's a product of this long-term democratization that has been occurring in the United States Republic since its foundation. But at no point was there a review that came back and said, well, if we're going to have universal democracy, the structural aspects of our republic, both in its judiciary and its electoral systems, should not hail from a system that is based on wealth. But that review has never taken place. I was going to talk about the way the Electoral College was designed to actually restrict the electorate to a disinterested landholding educated class. But with the amount of time I have left, I'll go right to election-related decisions. These are cases that pertaining to elections that have actually been tried by the federal judiciary of the United States. The most famous one is Bush v. Gore. This was in 2000. It's the only time the United States Supreme Court has ever actually directly decided the result of a presidential election. Their decision ultimately, in practice, selected George Bush for the victory over the presidency. This was highly criticized as a partisan interested decision, but it was decided on the narrow issue of the uniformity of the remedy for counting votes across the various counties where they were counted. They said that none could be created in time, and that the Equal Protection Clause of the United States Constitution could not guarantee the production of a remedy that would make any sense. So it ended up giving the presidential election to George Bush. Baker v. Carr, this was a case overturning Cowgrove versus Green, in which they held that questions of electoral redistricting are justiciable under the 14th Amendment of the United States, the substantive due process clause that I mentioned, specifically on the matter of redistricting or gerrymandering in order to create racial segregation, in order to disenfranchise the subaltern populations of people by relegating them into smaller portions of various districts where they're not going to have much electoral power. Gray v. Sanders is where there's the famous case where we get the phrase "one person, one vote." An interesting case that happened recently, this was actually not in the Supreme Court, but just in the Southern District of Florida, Wilding versus DNC Services Corp., in which a presidential candidate named Bernie Sanders sued the Democratic National Committee, that's the committee of one of the two major parties in the United States, saying that there was fraud and interested rather than disinterested activity and corruption concerning the way the election was handled in the state of Florida. And the case was ultimately dismissed. But one interesting thing that happened is an attorney for the DNC said in his argument that the political party, not being a branch directly of the government, has no obligation of a fair process whatsoever, no legal obligation, that they could simply, as the parties in fact used to do, go into back rooms as the powerful men in politics light their cigars and select a candidate such as suits them. And the court, in review of this, did in fact admit, while it may be true in the abstract, that is the case, which is an interesting thing to know about our judiciary and our democracy, is that our political parties are not obliged to have a fair process in the election of their candidates that could then go on to the general election. The case goes on to say that there are other ways of holding standards against the parties, but in fact, there's no structural legal standard for that. Rucho versus Common Cause, this was a very recent case in which the court ruled that it's actually not justiciable to have a lawsuit about the federal electoral districting if it is a matter of partisanship in the redistricting rather than racial discrimination. So that's one of the ways in which the judiciary of the court should have a great deal more power to review electoral misconduct than they do, but the procedural standards they have set up themselves have, as well as the structural makeup of the United States federal republic, of the states themselves, of the judiciary, all of these things prevent the average citizen from having much access to justice, much access to constitutional review, and even on such fundamental constitutional rights as a process for a fair election. We like to think that various protections we have in place are adequate for this, and perhaps they are, but yes, it's certainly not as excellent a standard of being able to protect your constitutional rights as you have in Indonesia, where any citizen can simply appeal to the constitutional court directly. I actually consider that to be a superior model to the United States federal judiciary system. So I believe I should be roughly at time. I'll check the, oh yes, yeah. Yes, that should conclude my presentation. I will stop the share. And thank you very much. I believe Iksan, you'll now moderate a questions period.
Sure, Stephen. As you can hear already, I don't want to repeat what Stephen said. He's talking about the one Supreme Court regarding the judicial reviews, and also talking about the systematical form of judicial review in the United States, which is divided into state court and federal court pathway. And he's also talking about the necessity of for the Supreme Court to have more power to review judicial misconduct and guarantee fair election and democratization. And now I would like to pass the chance to Dr. Palguna to give some questions or any clarification regarding Stephen's presentation. Dr. Palguna?
Okay, thank you, Iksan, and thank you for Stephen for your great presentations. I would like two questions about the United States judicial system, especially. We know that with the principles of supremacy clause in Article 6, if I'm not mistaken, paragraph 2, on one hand, and on the other hand, there are varied state judicial systems, like you already elaborated earlier. And so the question is how to maintain the spirit of supremacy clause within such a very judicial system in more than 50 states now, which is also so varied even within states. If I'm not mistaken, maybe the state of Louisiana is a very special one, who is considered to be the only state in the United States who applied the a kind of civil law system or something, if I'm not mistaken. The second question is, we know that not all constitutional cases reach the Supreme Court, even where the principle, the doctrine of what called it certiorari is applied. Because if I'm not mistaken, there are a rule of 4. Only when 4 of the 9 justices of the United States agree to hear a case, the case will reach the Supreme Court of the United States. And it means that many constitutional or even fundamental cases of constitutional law may be buried, quote unquote, within the state or the lower level of judicial system. And how, do you have any comment on these matters? Thank you, Iksan.
Thank you very much,
Stephen?
for your questions. Oh, yes. So on the first question, the Federal Supremacy Clause, that is an interesting subject. The average United States citizen, if they don't have legal education, they will generally understand the Federal Supremacy Clause to mean that anywhere the United States law, the federal law, and its given state law are in conflict, that the federal law is automatically voiding of the state law. But this is not actually the case. The Federal Supremacy Clause is somewhat limited. So, for instance, the biggest place this has come up lately, the Federal Supremacy Clause, is that many of the states of the United States are legalizing marijuana, whereas the federal government maintains that it's still illegal. And a lot of people in their political commentary in this are under the impression that it is illegal for the state to legalize it where it's federally illegal, that they're able to legalize it and do it in practice, but that in fact it should be illegal. But in fact, this isn't the case. The Supremacy Clause is narrow enough that no state law is in violation of the Supremacy Clause unless it is actually compelling a violation of federal law. So the federal government can say marijuana is illegal, the state government can say that it's legal, and there's no conflict in the Supremacy Clause unless the state government's law actually makes it mandatory to smoke marijuana. If it were to in some way make possession, cultivation, or the consumption of marijuana compulsory to any person, a group of persons, so that they would in fact be compelled to violate state law, or to violate federal law, that would be a violation of federal supremacy. The way our Constitution is devolved actually involves a great deal more constitutional authority within the states than in the federal government. But then the way in which we do actually end up getting quite a lot of uniformity, in fact, you could say in practice a lot more uniformity than you have in a unitary republic in Indonesia, is that the federal government just has a lot more money, has a lot more ability to organize things. It can pass laws under the Commerce Clause in which it actually just makes contingent funds that are going to states to help them with their various projects on their compliance with various federal policies and legal things, even though it can't directly tell them what to pass as laws. That would be commandeering, but money is a powerful motivator, so it almost always does that. It is true Louisiana has, it's the only state in the union that has both a common law and a civil law system in place. I think that's also true in Quebec in Canada, right, both due to their French influence, but yeah, I mean, so long as that, I mean, the federal court system ever since Erie Railroad versus Tompkins, where they no longer have their own federal general common law, is starting where they mostly interpret federal statutes and things. This starts to look a lot more like a civil law system, and that's something that's been under-recognized in the scholarship and commentary. We sort of are moving to something more similar to civil law than common law, or at least to a hybrid system. But yeah, that's about how it looks. As far as the certiorari, 4 justices are required to vote in favor of granting a writ of certiorari in order for the case to reach the Supreme Court. And as I mentioned, it happens in roughly 80 cases per year. And yeah, my general comment on that is that does create a situation in which most matters of the protection of constitutional rights, or even the decision of electoral questions or of electoral districts, etc., will not reach the Supreme Court, at least in a time frame where it actually benefits the people who are affected in their own situation. Generally, people are vindicated decades later by a future case. They will not immediately receive the remedy themselves. And I think that's unfortunate. It has something to be recommended against. In fact, that problem got severe enough that there was a congressional commission that was arranged in 1978 called the Hruska Commission, in which they wanted to review the question of splits of law, splits of the protection of substantive constitutional rights between the various United States Circuit Court of Appeals that I mentioned. And they found the volume of inter-circuit splits, the volume of ways in which U.S. citizens' rights were differently protected or not at all, depending on where you lived, was very impressive. They said it was a substantial problem, and that we should probably consider creating a national court of appeals where it would serve a similar function to the Supreme Court, but it would be at just one presidential level below the Supreme Court in terms of its horizontal authority, and have the ability to resolve inter-circuit splits between the United States Circuit Courts of Appeals, so that at least somebody would have the ability to take on the workload to make sure that protection of constitutional rights happened in a uniform way nationally. But that some scholars thought and some legislators thought perhaps that would violate the one Supreme Court clause. There's other models you could do too. In fact, you could have just like a single presidential environment of all the districts of all the United States Circuit Courts instead of having a distinct one for each one. But then you would need some kind of division of that court that was responsible specifically for making sure conflicts between them were resolved in some kind of efficient way. Unfortunately, just because of the political polarization in the United States that I mentioned, revisions to the judicial structure are extremely rare. It's very difficult for them to pass any laws about that. And then a lot of the time, even people who would be interested in passing judicial reforms that would enable the uniform protection of constitutional rights, that would enable even the court systems to simply have enough judges to not have such overwhelming caseloads. They, in fact, don't want to pass reforms to that, say, for instance, creating new judicial seats, if, for instance, their party is not in power, because then the party in power, having a majority of the seats in the legislature, is going to be, or have a president to appoint them and then enough votes in the legislative chambers to confirm them. They're going to get a lot more people of their party in the federal judiciary, which we're supposed to have an independent judiciary where that shouldn't matter as much. But in fact, it matters so much that the caseloads in the federal court systems are so great that the justices will admit to you themselves that they work so many cases that they probably are not even using their best legal reasoning in the dispensation of most cases, which, is a huge problem for a democratic society. The people have limited remedies in the court. It's an unfortunate quality of our system.
Okay, Stephen, maybe at the same time, if you have any question or any response to Professor Palguna, because Professor Palguna will be leave in, I guess, in 10 minutes.
Yeah,
because
I'm sorry. Yeah, because I have another Zoom meeting.
Yeah. So
Yes,
just keep it short, maybe in 5 minutes. So Professor Palguna can also respond it in 5 minutes, and after that, Your Excellency, you can leave to another forum. Stephen.
Oh, absolutely. Yes, Justice Palguna, it's an honor presenting with you. And I guess my question would be the procedure in practice where a citizen of Indonesia can write directly to the Constitutional Court of Indonesia for the determination of the constitutionality of the law. While there is no legal requirement that that person be represented by an attorney, are there any procedural inhibitions that make it impractical to file that without an attorney? Is the sophistication of legal knowledge required to make a good petition that way large enough that almost always you do want to be represented by an attorney?
Okay. Langsung Iksan ya. Okay. Well, thank you, Stephen. That's of course it is the real problem we face. Because we have the idea to how to make a justice seeker much more easier to reach the court, and then we let the petitioner with no obligation to be represented by a lawyer. But in practice, how to handle these difficulties is because we have a mechanism that before it reaches the in-depth proceeding, we have a kind of pre-trial, which is called the panel hearing. Panel hearing. The panel hearing comprises of 3 justices that will consult the petitioner how to make a petition, a good petition, and then and also he can search the how to make a good petition by searching the Constitutional Court website. That's even the Article 39 of the Law on Constitutional Court oblige the panel, the justices panel, to give a consultation or to give an advice to the petitioner how to make a good petition. I think that's the way to solve the problem of legal technicalities for a petition. Thank you. Maybe that's all I can say.
Okay. Professor Palguna, thank you for your attendance and your presentation today. We have a very lot of knowledge, and we will receive a lot of information regarding the latest innovation that has been done in the Constitutional Court, and we hope that we can see you soon in another event. So.
Okay, thank you very much. I'm sorry, Stephen, and sorry, I'm sorry, Iksan, and all participants of this beautiful moment. I should left earlier this occasion because another Zoom meeting is waiting for me for my presentation in my campus. Thank you. See you next time.
Makasih.
Ya, makasih, Fer.
Okay, Stephen, right now in the chat column, we already have a few questions. I guess maybe you can just try to answer these questions. Question from Alif. Alif asks how you respond concerning the election dispute settlement made by the Constitutional Court of Republic Indonesia after the latest verdict. Do we need to establish a special court to solve the election dispute?
Well, I would say in comparison to the United States system, you already have a highly specialized court on that matter. So I would say that it is, definitely within the temporal authority of the court to decide elections. That's stated very clearly in that article of the Indonesian Constitution. If it becomes politically untenable for some reason, then you would, just like anything, you have to make whatever compromise, make whatever alteration would be, demanded by the overwhelming pressure of the Indonesian electorate. But yeah, I mean, certainly, I do favor specialization of courts. Like, in fact, there's almost a pseudo specialization that occurs in the United States Circuit Courts of Appeals that I mentioned. A lot of those courts, because of the legal issues which tend to occur in those geographic regions, they actually just end up being far greater experts in certain areas of law versus the justices of another court. Our United States Supreme Court, although it is the Supreme Court, there are certain types of areas of law that it very rarely rules on. And in fact, tax law is one of those. Tax law in the United States tends to be a somewhat internecine and difficult matter. And popularly, the tax attorneys in the United States will be upset if the United States Supreme Court is about to handle a matter of tax law, because they do it so infrequently that the people don't consider them, in fact, very practically competent in the normal sense, not the legal sense, to review that question, and that their review is often going to make things worse, more difficult to handle. So if anything like that were the case, then that's where you start to have causes for specialization. The federal circuit court that I mentioned, that entire federal judicial district was created, I think in 1981, in response to the problem that there was disuniformity in decisions regarding patent law. And because patent law concerned intellectual property that was now being distributed so throughout the United States rather than any one locality, the way industry had developed, they were like, there is such a need for uniformity at the federal level that it is important to have a court that specialized in that subject. And so they created, and that one also hears appeals regarding international trade. But yeah, so long as you don't have any issues like that, I mean, you have a unitary rather than federal republic, although the court is new, and so it's going to have a lack of, a very detailed presidential environment compared to other courts of its type. As long as the handling of the electoral results seems to be going well, I don't see a reason for its specialization. I haven't read anything about, like, if the Constitutional Court has an excessive workload or anything like that. Concerns like that would be a reason to create a specialization. But even if you want to do specialization, you don't necessarily have to create a different court. Like, for instance, in Germany, they have court systems where there is a single court that is made up of some 200 justices, and each of those justices sit in particular divisions of that court. So it's the same body of that court meeting But for issues of specialized law, there is a division of, a particular handful of judges who are experienced in that area, knowledgeable in that area, will rule on that area. And in fact, even our U.S. Constitution would permit us to do something like that. And I see nothing in the Indonesian Constitution which would prevent you from having additional justices, perhaps even in significantly greater numbers, whose divisions were responsible for specialized issues like election law. But with the volume I've seen so far and what I've read, I don't think that's necessary right now. But that's
okay. Okay, Stephen. Bang Ferry, Stephen already answered the questions, and I think maybe it is a better time to you to ask a question or give some response first before we throw it to the participants.
Yeah, thank you, Stephen, for your presentation. You did mention about Miranda versus Arizona cases. Explain how important to give a right to a people who under custody. And there is a lot of cases right now that related with that verdict. As people around the world know about the George Floyd case, probably would you explain me the bonding power of the Supreme Court? Like we have like bonding power in Constitutional Court, which mentioned under the Constitution that constitutional court decision will be final and binding to all of the people. So it means all the people should honor and use that verdict to their daily life or organization. So what I want to ask you is, if in Indonesia somehow, even though a constitutional court already decides something, but in a political perspective, especially political in the House, they don't want to use that verdict. Is it also happen in America, especially under the Supreme Court verdict? I mentioned to you earlier that there is a case about Miranda, what we know in Indonesia, Miranda rules, and also a case of George Floyd is a really big case, and why they don't use the Supreme Court verdict on behalf of that case. I think that's only my question.
Excellent, thank you. So the binding power of the Supreme Court, that is a big subject. It does have the same degree of constitutional authority, where its decisions are meant to be binding on the entire federal government. But there is some ambiguity as to how much it is actually complied with in practice. Sometimes by itself. I mean, at this point, the presidential history, the stare decisis of the United States Supreme Court is so vast, because it's the same one that's been in operation since 1789, that there could, and in fact are, cases on its rolls that would affect the presidential environment in a different way than happens in practice. But because for whatever reason that case was never very famous, or just never in practice ended up applying to a lot of situations, so people just sort of literally forget. Lawyers can sometimes bring up precedents that are surprising to the court. One such authority is John Bad Elk, I think versus the United States. It was a case in which we determined in 1900 that a regular U.S. citizen still has the authority to shoot and kill a police officer who is arresting them on a bad warrant, if the warrant is procedurally incorrect, if the law in which they're being arrested is unconstitutional, and that would only be a misdemeanor rather than like a full criminal charge of homicide. But that's unless that's abrogated by a local statute by the state, which it almost always is. But yet it's like the various cases can just sort of fall by the wayside. So you'll experience the court almost cognitively struggling to comply with its own former cases. And then there was a very famous case of Cherokee Nation versus Georgia in 1831, in which Justice Marshall decided that it was actually unconstitutional to relocate the Cherokee Nation out of Georgia, but the then President Andrew Jackson, there's a famous quote that's probably apocryphal in which he said the Supreme Court has issued its ruling, let's see it enforce it, in which he was just saying, well, I have the means to, in fact, federally use troops and move the Cherokee out of that nation, and I can do so illegally, essentially, because the Supreme Court has no practical authority to stop me. They have no means of stopping me. That exact quote probably wasn't said, but in fact, the Cherokee were relocated in an event that's now referred to in history as the Trail of Tears. The federal legislature and the president, they're often in battles with the Supreme Court. In World War II, the United States president was often in litigation procedures with there was a famous case called Korematsu, which regarded the constitutionality of the executive to create internment camps to hold Japanese prisoners simply because of the potentiality of disloyalty. There was a Youngstown Steel Sheet Company case where it had to do with the power of the president under his emergency powers. The Congress is often passing bills that end up getting struck down, at least in some part, by the United States Supreme Court. And sometimes that's by new legal reasoning about the Supreme Court, or sometimes they're merely saying, look, this was already in violation of our previous decision here. We're striking it down. And that does get stricken and complied with for at least as long in history as people will remember that's the case. But, the Congress passes a lot of laws too. So there's not even any sort of guarantee in their brains that, they're not necessarily going to be extremely well educated on the stare decisis of the Supreme Court. And there's no specific educational requirements to be a U.S. House of Representative or a U.S. House representative or a U.S. senator. I mean, in practice, there's just one that you have to be the sort of person who can get elected. But depending on the state you're from, not all states have extremely good educational standards. So I'm sure all the time laws get passed which violate both the United States Constitution itself directly and findings of the United States Supreme Court. There was a case in 1989 where they said that it was not constitutional to ban flag burning as an act of protest or speech. And then the Congress has actually passed a law just saying, yeah, we don't want to comply with that. That's we're repassing our previous law. The Supreme Court quickly struck that down. But yes, you do get all kinds of internecine issues like that, where the rest of the government doesn't necessarily want to comply with the Supreme Court, and they have to be responsive and, in fact, grant writs of certiorari on questions that will reaffirm their authority, which they're quick to do. They care very much about the image, the appearance, the imprimatur, the legitimacy of the court. Oh yes, and on the Miranda Rights, that was an important case in that prior to that, states did not have to comply with that. You could infer guilt from a refusal to testify. You could and that resulted in a great deal of injustice, especially in the southern states where so much racial discrimination went on, especially in the criminal justice system. And that vestige continues that to this day. We still have a highly racially biased criminal justice system, both in the ways in which we apply and interpret constitutional rights that are written down in the Constitution, and the way they go in practice, which goes to the George Floyd thing. Yeah, that fellow was ultimately convicted, but yeah, there are procedural standards that the police ought to have in the United States, owing to their obligations under the Constitution, that they simply don't. There's just insufficient protections, and part of it has to do with a lack of political will. Until recent times, now political will is building up, especially the death of George Floyd, of Trayvon Martin, of many subaltern people who have been shot and killed by the police under unjust circumstances. Lately, there's a huge protest movement building. But prior to that, and in the whole rest of the country, aside from the protest movement, the general attitude about criminal law has been like, oh, anyone who violates the law, it doesn't really matter much. The prisons don't have to be particularly humane. The police officers don't have to be nice. They tend to respond lazily to the question of, well, should procedural criminal justice, go a certain way? Every so often, you'll hear them invoke very passionately protections about criminal law being applied, but generally this is in a case where they haven't already written off the person as just a criminal. which is, yeah, it's a difficult thing to do. And then, of course, our criminal statutes are written to a large extent specifically to punish aspects of poverty, aspects of being a member of a subaltern population, using a criminal penalty rather than a civil penalty. And that exacerbates that problem further. So yeah, I mean, part of the answer to that question about George Floyd is that to a large extent, our criminal justice system is structurally designed to promote a certain kind of industrial apartheid, which is why our United States Constitution's 13th Amendment actually says that slavery would be illegal in the country except as punishment for a crime. We don't, go around directly invoking that, much to say that, like, oh, the labor that we use amongst criminal prisoners in the United States is and don't pay them very much for is technically slavery, which we're allowed to do. Nobody says that enthusiastically, but it does seem to incidentally be the case. So yeah, I mean, just our Constitution is insufficiently instantiated as far as the rights it guarantees for our subaltern populations, almost by design. Sort of unfortunate, but yeah, that's my only answer to that question.
Thank you.
Okay. Bang Ferry, is there any other questions do you have there, or can we pass it to the participants now?
I think we can go to the other participants.
Okay. Is there any question from the participants in this room? You can just turn on your video and your microphone, and you can just speak directly if you have any questions. Ari, you want to respond to some of the presentation, maybe? If you guys don't have any questions, then I will be the first one to ask question to Stephen. You mentioned that during the development of a Supreme Court and judicial review in the United States, it is very difficult, or you said that the revision of judicial structure is extremely rare happening in the United States. But lately, I heard news that in April, President Biden has just appointed 36 member of a commission designed to, the news said that it is designed to some kind of a review or evaluate the limit of Supreme Court power in the United States, or maybe set some kind of a limit for the justice, or deciding to increase or decrease the number of the justice in the Supreme Court. This is one of the political maneuver, I can say, that made by President Biden. Is there any reason why you guys finally want to move forward from a very rigid and uniform character of Supreme Court into a more diversified and more limited power of Supreme Court, like what Biden tried to do?
Well, that most likely has to do, and of course has to President Biden's motivations in particular. I can only speculate based on public statements, what the news media has been saying about it and so forth. But probably the main motivation for that, if I were to be as frank as possible, would be just the current makeup of the United States Supreme Court, because the Republican Party was so successful under the Obama administration, specifically Senator Mitch McConnell, underwent a process to obstruct President Barack Obama's ability to elect new federal justices and judges all throughout the federal judiciary. In his, he used the idea that he's going to be a lame duck president. His term is ending, so we should allow the country to, select a new president by election, so that these new justices are chosen democratically. But that had never been done before, and also his standard of how long towards the end of his presidency was a lame duck presidency was much longer than had ever been considered before. It was essentially the last 2 years of his presidency. So consequently, there was Judge Merrick Garland that was appointed as a Supreme Court justice by the president, but not confirmed by the Senate because they refused to even begin the process of considering him. And they did that all up and down the entire federal judiciary as well. Consequently, when President Donald Trump was elected, there were not only vacancies in the Supreme Court, but also across the entire federal judiciary to the extent that he appointed some 500 federal judges, all at the federal district level, at the appellate level, at the Supreme Court level as well. And so, and then there were some inopportune deaths in the Supreme Court, since Supreme Court justices of the United States hold their position for life during good behavior, which is also known as the Bene Gesserit doctrine. Technically, Supreme Court justice could be impeached for bad behavior, but that's never happened. Consequently, it's 6 Republicans on the Supreme Court bench to only 3 Democrats. And not only Republicans, but Republicans who have particularly onerous views of constitutional hermeneutics, in which they seek to sort of eliminate any protection of rights that occurs prior to essentially the Taney Court, which is in the 19th century. And the will by the Democratic Party to alter that is very strong. They themselves also use maneuvers within the federal judiciary in order to affect political change. And so probably, so when they create a commission, the commission is, it's just some body that's assembled incidentally. Some money is set aside to it, and all they do is produce a report. The Congress can do that, the president can do that. The Supreme Court itself and the federal judiciary itself have various commissions and meetings and stuff they just set aside. So Biden's committee on the review of the judiciary of the federal government will produce some kind of report, and that will be influential. It will be cited by the legislatures, the members of legislatures who will try to pass legislation conforming with the changes he wants to make. One of the more outside accusations is that that report will be used as a basis to pack the court, so to speak, or to add additional seats to the Supreme Court during his presidency, so that he could appoint them and take away the Republican majority in the Supreme Court. Because that was attempted by Franklin Delano Roosevelt in the 1940s as well, or that might have been earlier than that, I'm not sure. But that ultimately was not passed. But yeah, right now the political polarization is so strong in the country that people are very terrified that there is, at least people in the Democratic Party are who make up a much larger percentage of the population, incidentally, but distributed across fewer states, so they have fewer representatives. They would probably be willing to take a roughly corrupt action in order to make sure that the power of the Supreme Court, either to directly review, was limited in some way by a new Judiciary Act, or they might try to increase their workload so as to create distractions for political maneuvering, or just to say, well, the Supreme Court takes only 80 cases per year. They would say, like, they should probably be handling more circuit splits, creating more national uniformity and so forth. But in fact, their intent would be to increase their workload so as to distract them from political maneuvering across partisan lines. May just ultimately be used to, in fact, create new seats on the Supreme Court. As has been done a few times before, just for practical reasons. Every so often they've just said, well, I think it had 5 members originally, and a couple of times throughout we said, well, we need additional members. The workload's too much. So they could end up saying that too. That committee report might end up producing something along those lines, but it might be politically motivated if they do say it. But yeah, and actually the workload problem that I mentioned across the federal judiciary generally might also get reviewed, because in fact they create new justices so infrequently that judges will admit to not being able to use their best reasoning on every case that comes before them. But yeah, I would say a highly politically motivated thing, but possibly for good reason. It depends on what those political motivations are.
Yeah. So you're trying to say that because under the Democrat point of view, the recent Supreme Court is too partisan. That is why the commission is created to balance the political influence within the Supreme Court, right? Okay. Yeah. If there is any question from the participants,
maybe me first, and then Bang Isan Kabula also would like to ask something.
Okay.
Okay, Stephen, thank you so much for your fruitful discussions and presentations today regarding the democracy and the constitutional court, particularly Supreme Court role in protecting the human rights and the democracy values in United States of America. I think this is the final project of the discussions we call the constitutional conversations. After this, you will focus on the final project for the co-writing with our director and another senior researchers. My questions regarding about the case, as already decided or hearing by the Supreme Court in America, in United States of America. As you mentioned before in your presentation, there is no many case will be heard by the Supreme Court. This the number or the quantity is quite little or not more. So could you tell us about what is the phenomenal or the spectacular issue that's already heard by the Supreme Court in the 2021 or 2022 regarding the democracy value or the protection of democracy value? Because as if I'm not mistaken, Professor Warren already talked to us and presented to us regarding there is an issue I'm not mistaken, is already decided in the 2018 regarding Masterpiece Cake Shop versus Colorado Civil Rights Commissions. This is one of the amazing and big issues in United States at the time in the 2018 regarding the discriminations between the cake baker don't want to make some cake for the LGBT couples. So this another interesting cases regarding the discriminations happen or heard by the Supreme Court in the 2021 or 2020 in the 2021 or 2020 regarding the discrimination through the treatment of the COVID situations and pandemic. Thank you.
Well, yeah, there's all kinds of opportunities the Supreme Court could have for that. That's one of the issues with the Supreme Court having a purely discretionary basis for granting writs of certiorari, including that discrimination is based on the votes of 4 justices. You have 6 justices now who are roughly politically in consort with each other, so they can even decide the docket however they want to. The votes of the 3 Democratic Party members of the Supreme Court are not relevant in matters of what they'll take certiorari on, unless for some reason there's a narrow enough legal issue that only some of the Republicans deal with it, or not a particularly partisan political or legal issue. That happens as well. But for anything that would be quite pointedly partisan for that, yeah, generally the Republican justices are going to agree. And then, of course, those are just the 2 parties, which, as I mentioned, the very electoral structure of the United States is designed to sort of or not intentionally designed, but by its design, it inadvertently limits political reasoning to that of the platform of 2 political parties. There are, of course, many, many more political parties in the United States who simply have no significant membership, no ability to win anybody in elections, have never had anybody sitting on the United States Supreme Court whose views are quite apart from the political views of the 2 parties. They remain utterly unrepresented. But yeah, so with their ability to by the discrimination select the docket, they in fact can even employ so much discrimination over the writ of certiorari to not hear cases on matters that would be beneficial to the political interests, the constitutional rights protections favored by the Democratic Party rather than by the Republican Party, and they most likely will use that somewhat generously. They federal judges are expected to have certain kinds of restraint. They're expected to adhere to certain standards of behavior that make them seem more legitimate. So for instance, conservative justices have ruled in favor of issues of civil rights that would be favorable to Democratic Party interests recently, just to, you could almost say sort of as an appeasement. Another way in which they can affect that is that there are very narrow standards for how the Supreme Court will decide its cases. There was this case called Ashwander, where they determined that if the Supreme Court can dispense with a legal question on a very specifically and narrowly tailored legal issue, and would not have to make a precedential decision on broader legal questions than that one, then it sort of compelled to do it that way, to leave it as narrow as possible. And the Supreme Court's always theoretically doing this, but in practice, determining exactly what that would be would require a far more extensive breakdown of like all of the legal possibilities, all of the logically determinable, deductible outcomes of every legal point in the case before you could actually figure that out. And there's no standard that says, there's no procedural standard that says, okay, if the Supreme Court is going to decide something on a narrow as possible legal issue, that some process has to be taken to guarantee that the court even knows what that is, the narrowest possible legal question, before it decides the case on it. And so they'll often be passing cases that they are saying is based on the most narrowly tailored legal question, but in fact has some kind of deeply partisan motivation. As far as how it'll affect people in the pandemic, I am not extremely up to date on what the Supreme Court's docket is right now. But one major issue that's come up with the pandemic is just that, while people are in fact unable to work safely, a lot of them have no source of income. There's been temporary provisions. There's been stays on moratoriums on eviction from apartments where people rent from landlords. But there was no provision, there was no rent forgiveness. So the rent is not due, you cannot be evicted on the basis of not paying it, but also you will owe it once these moratoriums end, which in fact one recently did. So many people are now, in debt, thousands upon thousands of dollars in rent for the place where they live, where, of course they weren't making money at the time is the reason they accrued that debt. So they have no means of paying it back. And those people will then are now being evicted in very large numbers. I'm sure matters might come to the Supreme Court's attention on that, whether or not rent forgiveness should be attended. Simultaneously, no mortgage forgiveness was attended. So people who in fact own a house but do it under a bank loan rather than renting for a landlord were left to whatever devices were available to them. Those are generally a slightly richer class of people, but not always. So it's that was a major pandemic concern. I'm sure many issues of tort, of medical malpractice, of general negligence by the government, the equality of enforcement of various provisions. There's that's going to be the pandemic is going to be a source of innumerable legal issues for the Supreme Court that probably continue to be litigating it for the next decade. So I have less specific comment on that, but yes, the ways in which they will use it to partisan advantage will be numerous. Will have to do with where they grant certiorari, how they state their reasoning, and the tailoring of the narrow issues in which the decisions are decided.
Ari, is that enough explanation? You got it? Okay. Next question from Bang Isan Kabullah.
Thank you, Isan Alia. Stephen, good night, I think, in there. And it is a very interesting discussions, and we very get we learn many things from your presentation, also from Pak Pal presentation. Actually, in most of country like Indonesia, we have a challenge to protect the democracy process. The oligarchy become more powerful or stronger when political elite could intervene the democracy process. In Indonesia case, we get the problems to protect democracy, like the issue of the third period of president, which is now the president periods only 2 periods. Also, like the creations of the Corruption Eradication Commission's performance to against the anti-corruptions. The political elite revise the law, and the commission not perform very well. At the same times, the Constitutional Court in Indonesia seems not perform very well to protect the democracy. I would like to know, with the U.S. experience, especially with the case of Donald Trump and his supporter attempted to neglect the elections result in the last elections, how the Supreme Court work, especially to neglect the political interventions like in the Donald Trump case, because in Indonesia case, I believe it is a very hard to court to protect that. Just that, maybe Stephen. I hope you understand with my word. Thank you.
Thank you very much. Yes, the protections are somewhat inadequate in the United States. I mean, just as they often are. I mean, I guess the entire human race is working on the project of good government, but there are specific criticisms to be made of it. As I mentioned, since the writ of certiorari is voluntary, the federal election matters tend to get to the Supreme Court because people consider them politically important, so they'll get through procedural expedients. Also, because they're on timetables, federal courts at any level can be made to meet more quickly if there will be irremediable harm or irreparable harm, unless they issue certain stays and then decide the cases very quickly. So because federal elections are generally on timelines, those questions will get to the Supreme Court more quickly if they're going to get to the Supreme Court. But this is one of the interesting things about the Electoral College and the devolutionary federal model of the United States Republic is that generally when Donald Trump made his several complaints about the United States the election procedure of 2020, he is not filing a suit that's going directly to the Constitutional Court. It's not a single lawsuit that's going before the review of any one court or of the Supreme Court specifically. These are state law matters. The way in which elections are run, they're subject to federal election law, but generally, because of the system of the Federal Republic, the way it's structured, if you have a complaint with the way an election was conducted, then that is going to be with that state government, with that state's Secretary of State, or with a specific company that happened to run the ballot procedures for the state if they incidentally use somebody private rather than handling it themselves. And so he had, I think, roughly 11 lawsuits about the electoral procedures, accusations of fraud. They were targeted at specific states. The procedures of Pennsylvania was the most bright line of them, and so these things actually, they get decided partly in state courts, partly in federal courts, depending on how the specific jurisdiction matters work out for that particular case. And so then, as I mentioned, the problem of our general disuniformity, different procedural rules and laws apply to the different courts who are hearing the cases. Different legal standards, in fact, apply to them because the state court is going to be evaluating partially its compliance with federal election law, but also it's a consistent application of its own electoral law and the way the election has been carried out in practice. And then the federal court, when it hears the case, it will be reviewing it based on those same state law standards, but it'll be doing it using its own judgment. Technically, it's supposed to echo the judgment of the state court, but cognitively, there's no real guarantee of that. So, for instance, in Bush versus Gore, that was the famous case I mentioned where they actually ended up selecting George Bush as the president, sort of indirectly. But they used the interpretation of the Florida State Supreme Court when they had said in their opinion, actually just a very, very narrow thing. They had said that December 12th, year 2000 was an outside deadline for the latest that a constitutionally sufficient remedy for the recounting could be done for having any kind of solution to the case. And they construed that strictly and said, well, if the opinion of the Florida Supreme Court that February 12th is the last, that December 12th is the last possible deadline, then we can't violate that, and the Equal Protection Clause would prevent us from creating a justiciable and an equally protective remedy, and so constitutionally sufficient in that time. But yeah, there's no structural guarantee. At no point can the candidate just say, I contest this entire election, and so I wish to have one case attending all issues of corruption, possibly attending it. The candidate has to, of his own power, of his own ability, of the ability of his own staff, locate specific things that were done, specific instances in which they believe fraud has occurred, specific procedural issues in which they believe a ballot was misconstructed or some specific kind of actual corruption occurred. The most famous case like that was probably in 1876. We had a presidential election between Rutherford B. Hayes and Tilden, I forget his first name. That was also a case in which members of the Supreme Court decided the result of the election, but that wasn't actually sitting as the Supreme Court. That was part of like a 15-member commission, I think. And one of the ways in which we were able to identify that some corruption had occurred specifically in the electoral process was that there was one state where 101%, 101% of the eligible electorate of that state had voted. Because back in the 19th century, the corruption was bad enough that, there was a practice called cooping. People would actually, you would go vote because you were a good citizen, but then some interested political hireling will come and actually abduct you and shave your head and have you go back and vote another time because you'll be able to identify somebody else, and then they'll shave your beard and do it again. Then they might drug you, beat you up, or kill you. So things like that happen. Now, the actual instances of fraud and corruption that happen in federal U.S. elections don't tend to be so severe. Our election law has gotten pretty strict on several areas, but so that the procedures, the way they structurally start, are pretty good nowadays. But yeah, if you have a way, if you must contest that election result, you have to identify specific issues of fraud or mishandling, misconduct, corruption, and then you have to go litigate either in those states or with sufficient jurisdiction to go to a federal court in that area, and then see if it reaches the Supreme Court. And when it does, it'll go so quickly. Donald Trump's cases in particular were found to mostly be based on specious accusations, which was also the political sentiment of half of the country when he started saying that. He started saying that there was going to be corruption in the handling of the 2020 election long before the 2020 election ever occurred, long before it would have been realistic that any measures for the organization of the election had even occurred yet. And he just sort of just kept saying it. And people sort of took the interpretation that he was under the impression he was going to lose, and so started throwing accusations of corruption in the event that he could somehow have a Hail Mary, a way of overturning the results of the election with an accusation of corruption at just the right moment. Now, wherever you fall politically is generally what determined whether or not you agreed with that claim. But at least the federal courts, made up of, in fact, diverse parties, the United States Supreme Court, with its Republican majority, did ultimately dismiss rather than grant writs of certiorari to hear Donald Trump's several cases attending the handling of the 2020 election, because they found the legal basis of them to actually be too specious. So but right, say it was a real matter. Say, in fact, there was substantive fraud, and then you just had the justices of the Supreme Court, perhaps you had paid them somehow, had in fact successfully manipulated corruptive mechanisms enough that they were politically sided with you. And so they simply declined to grant a writ of certiorari because they were politically interested on that side. Here, Republicans were actually turning down a review of the former Republican president. So you could say that wouldn't be a corrupted, motivated thing, but say it were. Say you had corrupt justices. Nothing structurally prevents that, except that if they were discovered, that would be a basis for impeachment. But it's generally felt in the United States that politicians in high offices get away with political corruption all the time. That just no evidence is found because they're rich enough they can go to obscure enough rooms. Incidentally, there haven't been that many accusations of corruption occurring within the Supreme Court, mostly just partisanship, lack of judicial restraint, excessive judicial activism. Corruption itself has not been mentioned that much, but yeah, unfortunately, in our federal electoral system, there is not any structural remedy, nothing that would guarantee the ability of a candidate who, or even of a regular citizen. I mean, the candidate themselves has to identify sources of fraud that might have interfered with their rightful election. But say you're just a citizen of the United States and you wish to file a lawsuit saying, like, I saw something corrupt happening, and I'm a citizen. I want the just democratic results to out at the end of the day. That would probably give you insufficient standing. You would actually probably not be competent in the legal sense to bring that case before a federal court. So yeah, unfortunately, my answer to that is that our protections in that area are insufficient. But then our immediate structural regulations as to how federal elections are conducted, those are fairly rigorous to begin with. The federal elections generally go pretty well in terms of how much corruption it actually ends up affecting them. But if you do have a complaint, if corruption does occur, the remedies for stopping it are limited.
Thank you, Stephen.
Okay, Stephen, thank you very much. That will be the end of our session today. Thank you to all of the participants. Thank you to Director of Pusako, Dr. Palguna, and Stephen. Thank you for your attendance and your sharp and comprehensive analysis regarding the U.S. Supreme Court and judicial review system. And I hope that your internship program will be finished completely, and you'll be satisfied with every knowledge and every networks that you have been set up during your internship program. I, as the moderator, would like to apologize to all of you if there is any inconvenience, I would say, during our session today. And I would like to return the podium back to Ari Wiryadinata. Thank you, Stephen. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you so much for Isan Alia to be moderated this panel sessions. As mentioned by Isan, it is the final project of the constitutional conversation, Stephen. So there is no more constitutional conversations organized by Pusako, but we would like to focus on your final project to co-writing with our director and maybe another senior researcher. We hope that your 2 cents or writing journals could be if it is possible to be published in the Scopus. I hope so. So again, thank you so much for everyone who attended these sessions, and see you in the another project or another sessions organized by Pusako. Very good afternoon from Indonesia, Stephen. Oke, makasih semuanya. Izin lab ya. Dadah.